Welcome to the DisabiliTEA, a podcast where we have candid discussions about all things related to disability. Short-term, long-term, financial claims, impact on other areas of life, causes in the workplace, and more. With your host, attorney Anjel Burgess. You can find this show at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more. Now here's the host of the DisabiliTEA, Anjel Burgess.
Hello and welcome to the DisabiliTEA. We are so excited today to have a repeat guest, attorney Sandy Burney, who is here to talk with us today about guardianships. So welcome back, Attorney Burney.
Hello. Thanks for having me back. Glad to be here.
Well, we are so excited to have you again. Some of our viewers may not have been able to watch the first episode with you. So if you could just tell us a little bit about you and then we can dive right in.
Okay, certainly. I am primarily a family law centered practitioner. I do handle some other practice areas, but primarily family law. So that usually entails family related issues, divorce, custody, probate, guardianships, legitimation, just things that are closely connected to families. I've been practicing for over 15 years. And as I said, that is my primary practice.
Okay. And your office is located in Atlanta?
In Atlanta, Cobb County, near the Battery Stadium, very close to that. Yeah.
Wonderful. Well, today we appreciate your time in talking to us about guardianships. So I get a lot of questions about guardianships. First, can you tell us what is a guardianship?
Well, a guardianship is basically a legal process recognized by the court when perhaps a person believes that another party needs an adult to sort of preside over or take responsibility for that person's decisions and or finances. And I say and or because you can have guardianship over the person, meaning their decision making. And you can also establish not really a guardianship, but it's called conservatorship over the finances. And so the two can be together or they can be separate.
And so for a guardianship, if there is a situation where, let's say, parents have a young adult who, they've of course cared for the young adult's entire life, and then the young adult turns 18. Mom and dad are still mom and dad, right? Mm-hmm. So why would mom and dad need a guardianship?
Mom and dad might pursue a guardianship in the context of the child, even though he or she may be 18. For example, they might have a mental illness that precludes them from making the best decisions for him or herself. So that would be one instance. Another instance may not have to do with mental incapacity, but maybe physical incapacity. The child or the young adult was then involved in a car accident, is in the hospital, can't make certain decisions that are required to be made for him or her.
All right. And so even though in this example, the young adult has turned 18, can mom and dad still make those kinds of decisions for that young adult if the young adult is unable to, without a guardianship?
Without a guardianship, mom and dad might be able to make those decisions on a very limited basis.
Okay.
If decisions are going to be required more long-term, I would always advise that, mom and dad talk to an attorney, perhaps think about guardianship.
Okay. Now,
Um,
I'm sorry, go ahead.
I was just going to say, you don't want to end up in a situation where you can do it without a guardianship, and then you get further down the road and then something comes up and you need that guardianship. It's going to take a little bit of time and effort to go through the process.
Okay. So with a guardianship, if in this example, mom and dad become guardians, and now they're able to make legal decisions for their young adult child, does that young adult child still have the ability to make legal decisions for him or herself?
No, and that's a great question because it sounds very much like a power of attorney.
Okay.
And so I get those calls a lot where people want to get a power of attorney versus a guardianship. And so the distinct difference is if mom and dad gets the child's power of attorney, they can act on the child's behalf. However, the child can still act on his or her own behalf.
Okay.
And so that is the primary distinction between a power of attorney. And I think power of attorneys are generally probably more limited in time and scope. And so you would generally only think about a power of attorney in a limited type situation. If it's something that's going to be long-term and more permanent, you may want to consider a guardianship.
Now, are there different types of guardianships?
Yes, so certainly there is a contested guardianship versus an uncontested guardianship. And the primary difference is who are these other people that are going to be involved and whether they're going to consent or not consent. Okay. And I say other people because the ward, which is the person that mom and dad would be seeking guardianship over, right? We'll call that person the ward.
Okay.
The ward may agree and the ward may disagree. Okay. But in the case that you presented in the example, mom and dad and the child being the ward, there may also be other siblings involved or other family members. So the question then becomes not only whether the ward is going to agree to it, but what's going to be the position of the other people in the family. Okay. And that determines whether you're talking about a contested case versus an uncontested case.
So if mom and the ward, let's say mom and dad and the ward and the family members, the immediate family members all agree that, this person needs a guardianship, is that an uncontested guardianship?
That is uncontested. So the process is the same in terms of the paperwork and the process that you would go through. The only difference is if it's contested, which is not your example. Your example is uncontested. Everybody's in agreement. Then it's just getting the paperwork through and it's usually smooth sailing. In a contested case, there's going to be a hearing.
Okay.
And that's the primary difference.
So I think for the purpose of our listeners and viewers, that it may be easiest to first talk about the contested guardianships. Because with that example, somebody's not going to agree to the guardianship, right?
Correct. That's correct.
So I would imagine, I know I get calls from time to time from parents that are trying to seek guardianship over, their adult child. Mm-hmm. And usually the context that I see this in is maybe the adult child has some mental illness. Mm-hmm. And so when I ask them, does this adult child agree that they need a guardian? And sometimes the parents say, well, no, he's not going to agree to that. He thinks that he can take care of himself and he can, manage his medication and he can make decisions to keep himself healthy, but we know that he can't.
Right.
So in that scenario, that would be a contested guardianship.
That is a contested guardianship.
And so what does that process look like? If mom and dad know that, their adult child is not going to agree to the guardianship, or that maybe some other close family member is not going to agree to the guardianship, what does the process look like?
So the process would be you would, mom and dad would contact an attorney who specializes in that area of the law. A petition would be filed. Okay. And that is a petition for the appointment of a guardian. Okay. In that petition, it basically asks for certain information that the court is going to be looking for. Okay. One of those things. Can you hear me?
Yes.
Okay. My screen went out. One of those pieces of information that is going to be requested is to identify who these other family members are.
Okay.
Because they're going to have to be served and notified.
So you have to make other family members aware that you are petitioning to be the guardian.
Absolutely. This is not a process that's going to be done in secrecy or in darkness. And the only sort of exception to that might be if an emergency guardianship were needed, then you would not need to notify because it's an emergency. But at some point, you have to get a permanent guardianship. So the emergency only lasts for a very finite amount of time.
Okay.
So the parties are going to have to be notified. There's going to have to be some indication in the petition that the ward, in your example, the child, is unable to make or communicate significant, responsible decisions regarding his or her health and safety.
Okay.
And that's primarily what the court is going to be looking for. What is that evidence? And so you'll be able to, put in a narrative. The child has been diagnosed with, whatever the mental illness is, right? And because of that, he or she is unable to take medication as prescribed by the doctor, right? Is unable to attend doctor's appointments without some sort of assistance. Those are the types of things that the court is going to look at in the petition itself.
Okay.
Also included in the petition, you got the notification, you got a summary of what is going on. Also, what are the child's income? What is his or her income? The financial aspect comes into play as well. So you do have to list what sort of assets the ward has, what liabilities the ward has. Okay. So the court is going to want sort of a comprehensive overview of all of that. And once all of that is done, the court is going to appoint the ward an attorney.
Okay.
So he or she will get their own attorney. There'll be a guardian ad litem appointed for the ward. That person will go out, and I call him a guardian ad litem, but it's also like a court evaluator.
Okay.
Or guardian ad litem. And so they will also go out and meet with the ward, try to determine based on that summary, what's going on. And then they will provide the court with a report. Yes, we think this person is in need of a guardian. No, we do not think this person is in need of a guardian.
So it sounds like with the contested guardianship that there are 3 attorneys that are going to be involved. Is that correct? So there's the attorney for the parents. Mm-hmm. There's the attorney for the ward. Mm-hmm. And then there's the guardian ad litem.
Correct. Now the guardian or the evaluator's position is only to go out and try to make an assessment and determination as to whether they think the ward needs a guardian.
Okay.
They won't have any role in the court process itself other than to submit a written report to the court.
Okay. So that person is really not on anybody's side, right?
Correct.
Okay.
They're going out to do an evaluation and that's it. They're going to take the petition. They're going to read it. They're going to say, okay, I understand from the parent's perspective what's going on. Now let me go out and talk to the child and see what's going on. So their job is only to make an evaluation.
Okay.
right? And then issue a report back to the court.
So the attorney for the child is there to advocate for whatever the child wants
In court.
in court. Okay.
In court, yes.
So even if what the child wants is not what the child needs, that attorney is still there to advocate for what the child wants in court.
That's exactly correct.
Okay.
And as you know, those two things may not
Right.
often match up, right? What the child wants versus what the child needs.
Right.
And that's why you have two distinct parties representing the ward. You have an attorney who's advocating for the ward in court, and then you have basically a guardian or an evaluator who's going out taking a really a fresh set of eyes, a truly objective perspective on what's best for the ward.
So when there is a court hearing, I'm assuming that everyone gets the opportunity to present their perspective and their evidence for the judge.
Yes, the court will at that point have the written report of the guardian or the evaluator. And then each party, the parents, will be able to bring forth any witnesses, any other evidence they may have to support their petition. And the ward will be able to do that as well.
Okay.
And the ward will be there to testify. No, I can manage my own finances. I can make my own decisions. I can do, any number of things, which is what I would expect in a contested case.
Okay.
I would expect also that the parents would be able to demonstrate, no, the child can't make these decisions. Here are some examples. Here are some witnesses. Other things that might be important is whether the child can perform what we call ADLs, right? Activities of daily living.
Right.
Can the child eat or drink or prepare meals? Can they take medication? Can they attend to their hygiene? Those sorts of things independently without the assistance of another person. Those become critical.
And then from there, after there's a hearing and both sides have presented their evidence and the guardian ad litem or evaluator has presented the report, does the judge then make a decision about whether the guardianship is approved or how does that work?
Yeah, so let me just take one step back before I answer that. In the presentation of evidence, you also have to deal with whether there's going to be a conservatorship needed.
Okay.
So if the ward, for example, has income, I don't know, Social Security, disability income, right? All of that evidence would come into play, and you'd also have to notify the court whether you're looking for a guardianship and conservatorship or guardianship. And that has to be identified in the petition.
So is there a certain threshold or particular source of income that is going to trigger the need for a conservatorship?
No, there's not a certain threshold. It's really just going to amount to how much income the ward has, the proposed ward has, and what their expenses look like.
Okay.
And the whole reason for that is just to minimize, right, any sort of abuse of funds that may be coming in. So if the ward is getting, I don't know, $20,000 a year, but lives at home with mom and dad and really don't have any expenses, then the court may want to put certain safeguards in place, like a bond.
And so to protect
the ward.
Those funds. Okay.
Yeah.
Now this process with the contested guardianship does sound like it could get a little lengthy, and it also sounds like it could get expensive. How does the timeline differ between a contested and an uncontested guardianship?
So typically the timeline, and I think you previously asked me a question about making a decision too, so I don't want to forget to come back to that. At the end of the hearing, and it just depends on the county, the judge. Sometimes they make a decision right from the bench. Yes, we do think that, little Johnny or little Sue, the proposed ward needs a guardian. And so I'm going to grant that, da, 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 da. Sometimes they'll take it under advisement.
Okay.
And it just really depends on the complexity of the case, whether it's something that the judge can kind of don't have any unanswered questions at the time of rendering his or her decision. In terms of the length of time of the process, it's about an average time of about 6 weeks.
Okay.
From the filing all the way through to the hearing.
Okay.
It's done a little bit quicker if it's an emergency. Okay. If it's an emergency, it's going to move in about a week and a half. Again, same process. The difference is an emergency, the judge, the court is going to be looking for some sort of emergency type circumstance. Everything is expedited, and it only lasts for about 60 days. And then you file for a permanent one.
Okay, so the emergency guardianship is of a temporary nature.
Yes.
As opposed to just the regular guardianship, which is permanent.
Yes.
Now, what happens? Well, actually, I didn't give you a chance to ask the next question, answer the last question about the cost. So let me go back to that before I ask my next question. So it would seem as though it would be much more expensive if you have to pursue a contested guardianship versus uncontested.
Yes, because like anything else, if you're gonna have to get an attorney and you're gonna have to go to court and there's got to be a hearing, there's got to be witnesses and time and expense. Yes, it can definitely be more expensive than an uncontested case. The filing fee is, I should have looked that up because I can't remember off the top of my head. The filing fee is around $300-ish.
Okay.
Maybe 500. 3 to 5. Let's say 3 to 500.
Does that vary from county to county?
No, that's the same amount in every county, pretty much.
Okay. All right.
And then aside from that, you would have whatever fees that your attorney, the parent's attorney, would charge, and that's about it.
So who pays? So if the parents are saying, I want this guardianship, and the adult child is saying, I do not want this guardianship, who pays for the adult child to have an attorney?
The court does.
Okay.
It's part of the court process. The adult child gets a court-appointed attorney.
Okay.
And then the fee for the guardian, which is very nominal, is also passed on to the parent, and it's included in that. Let's call it $500.
Okay.
Filing fee.
Okay, so the filing fee includes the evaluator's work and report, but it does not include the ward's attorney.
That is correct.
Okay.
That's correct. And then the process is pretty much the same if it's uncontested. The only difference is you're not going to have a hearing. So all of the same documentation gets filed. It moves through the court and through the process pretty much the same way.
Okay.
It's just no court hearing because everybody's in agreement and everybody's on the same page.
And what about the permanency of the guardianship? So what if, mom and dad are able to get the guardianship and it's because the adult child, let's say, has a mental health condition, and let's say the child is in agreement. So we've got an uncontested guardianship, and then a new medication comes out. And that new medication works really well with the adult child, and the adult child gets stable, and they, start, taking care of their own needs, and, is that guardianship, does it have to be permanent, or is there a way that that adult child, and maybe even the parents, can agree and say, you don't need this guardianship anymore?
There is, and I'm glad you asked that question. It is permanent, meaning you don't have to do anything after the court grants the guardianship.
Okay.
You do have to file what's called like an annual report. Just keep the court updated on, any changes that are necessary. But in that situation, proposed ward is doing better, no longer needs a guardian. They can file even a joint motion to revoke the guardianship.
Okay.
Yeah, and that happens. You go into court. It's not a big long process. You go into court, explain to the judge what has happened. Guardianship gets revoked and dissolved.
Okay.
So yeah, that can happen.
And so I'm assuming that there would have to be some evidence, again, produced for the court to determine that the guardianship can be dissolved?
Yes, evidence or by agreement of the parties.
Okay.
Their mom and dad come forward and say, yes, John or Sue or, proposed ward is doing much better, is able to handle everything on his or her own, can live independently, can making decisions. We no longer feel like we involved.
Okay.
Yeah.
Well, that's great news. So the last question that I have for you, I know we've gone over so many things, is can you give us some tips as to, how parents, because that's usually the scenario that I see, how parents can decide whether or not they should pursue guardianship?
Yeah, that's always a tough one. I would say that parents, maybe some tips that parents can take away. Think about the capacity of the proposed ward and whether, and so we're not talking about somebody who may occasionally forget to take their medication, right? We're talking about an ongoing, recurring type of event that if it happened often enough, it could put the proposed ward, their health and safety could be jeopardized.
Okay.
So that's sort of how you want to think about it through that lens. Can they make those decisions independently? If they, if it gets to the point where you feel like they need a little bit of help, or more than a little bit of help, then the question becomes, what about those other things? Can they drive? Can they work? Can they take care of their own, like day-to-day grooming and hygiene? Can they prepare meals? How will he or she eat? Can they take a bath? Do they need assistance sleeping? Or do they need a medication? Or are they up at night? Those sorts of things I would think would be, where you'd want to think about, okay, maybe a guardianship would be appropriate.
Okay, that makes sense.
Yeah.
All right. Well, are there other tips or tools that you'd like to share?
Absolutely. How can they manage their finances, right? If they have bills, can they get those paid? And depending on the situation, you don't want the proposed ward to be subject to, being taken advantage of. Right. And so, I know from personal experience, because I was the guardian, of my grandmother for a number of years, including while I was in law school.
Okay.
And so, you want to think of it as a preventative method as well to keep certain things from happening to the proposed ward. So I would say definitely think about that. Another tip, talk to everybody in the family. Sometimes a lot of stuff can be avoided just by having a conversation, right? What if the proposed ward is married and the spouse doesn't agree or does agree? Just sit down and have a discussion about it, because whether it's contested or if it's contested, right? None of this stuff is going to happen in the dark.
Right.
Unbeknownst to everybody else. So just sit down and have a discussion, and maybe everybody can come to an agreement about it. Another tip, think about what the ward's financial situation is, and make sure you have a good handle on that, because that is something that the court is going to want to know about. Income, debts, those sorts of things. And then, most importantly, be prepared to identify who the guardian will be.
Good point.
One that the court will want to know. Who's the guardian going to be? Who's the proposed guardian? Who's the proposed conservator? Who's going to be this person charged with making and executing those decisions? So that's it.
All right. Well, thank you so much for sharing so many good tips and clarifying things. I know there are a lot of questions about guardianships, and I know that it's a difficult decision for a lot of families. So I think that you have clarified things, made it a little bit easier for families to, reach a decision that can best meet the needs of that proposed ward. So thank you, Attorney Sandy Burney, for joining us again.
Thank you for having me.
And we've thoroughly enjoyed everything that you've shared with us. So this has been another episode of the DisabiliTEA, and we look forward to talking with you next time.
Thank you.
You've been listening to the DisabiliTEA with Anjel Burgess. Thank you for your positive reviews, comments, and sharing the show with others. You can catch prior episodes at www.disabilityhelpline.com and on YouTube, Facebook, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, Stitcher, and more.